Wow, that's loud. I think I'm on. So first of all, thanks
Mr.
for
Chairman?
joining us. And I think the House has really three main issues with your amendments. And so I'm going to walk through those three things, and then we can work on how we come to compromise on them. And so first of all, it'd be on page 7, and then it follows on to page 8. And this is where, you bet. So what the House basically did is that we said that a rule is not going to be in that our law, that the rest of section 2 is not going to be in effect unless there's a court stay. And that's just the short version. And so if you read through it and start with B, no public entity shall enforce any mandate or standard of the federal government, whether emergency, temporary, permanent, that requires an employer to ensure or mandate that employees shall receive a COVID-19 vaccination. The House version goes on as except otherwise provided in this section, to the extent that this section conflicts with federal law, regulation, rule, standard, or subsection B of this section shall not be enforced after the federal law, regulation, rule, standard, or order takes legal effect that requires Wyoming employers to comply with a federal COVID-19 vaccine requirement or mandate. So basically it says this, to the extent this conflicts with federal law, regulation, it goes away. So goes away. And then it goes on to say in subsection D, notwithstanding subsection C of this section, subsection B of this section shall be enforceable during any period in which the federal law, regulation, rule, standard is subject to federal judicial stay applicable in Wyoming. And so we feel like we have covered the bases as it relates to our healthcare entities and the state entities. But it basically says we're not going to cede our power. The state is not going to cede our power during a stay. What your amendment does is as soon as litigation begins, as soon as anything is filed, it goes away. Our lawsuit is just melts until such time that a federal law or federal rule is actually enforced by the court. So that's kind of us. We would really like to keep our language. We think it still protects public entities, but we think it allows the state to retain its authority, its sovereignty a little longer. And then on section 3, remember we just had a simple section. You turned that simple section into A and then created a B. And so section 3, with the direction and consent of the governor, the attorney general's office may initiate or participate in litigation and take any other appropriate action to challenge and resist federal government action related to COVID-19 vaccination mandates that are contrary to the law and the rights of Wyoming citizens. And then your amendment goes on in subsection B and says litigation under this section may include Romanet I, initiating an action in the name of the state of Wyoming as a party aggrieved. And I want to reiterate something under your B. It said litigation under this section may include, not a shall, may include Romanet I, initiating an action in the name of the state of Wyoming as a party aggrieved by the violation of the 10th Amendment. And it kind of goes on. And then Romanet II, initiating a class action lawsuit on behalf of the state of Wyoming. And then it goes on. And our problem is in that Romanet II. And our solution would be the following. It would be initiating a lawsuit on behalf of the state of Wyoming as lead plaintiff, or joining a lawsuit initiated by Wyoming citizens or others who were personally injured or whose livelihood is negatively affected by federal vaccine mandates pursuant to 91603A Romanet 4. And that goes back into into the authorities of the Attorney General. And that section, that subsection, that Romanet 4 states the Attorney General shall, that's A. Romanet 4 is represent the state in suits, actions, or claims in which the state is interested in either the Wyoming Supreme Court or any United States court. So it's a fairly broad authority for the AG, and so that's kind of us. We're worried about specifically going into class action lawsuits. I think we've tried to avoid that in the past, but it goes back and allows the Attorney General or current authorities, and basically makes a point, I think, that we want the AG to look at these cases. And so that's our section 3. And then the only other concern we have is section 4, which is the appropriation. And we think 10 million is a bit too much. We have plenty of time to appropriate more money. And we would like to reduce that back to $1 million. Obviously, there's some negotiation in there that could happen for sure, but our initial proposal on that would be $1 million. So that's kind of where we're at, and kind of what our solutions might be. And so I would turn it over to my Senate colleagues for discussion, or the House colleagues as well.
Mr. Co-Chairman, if you could walk me through, and particularly on subsection, on your second amendment, where we brought in the concept of class action suit. And then you just did a good job of, but could give me the difference as you see them as to what our language does and what yours does. And give me a contrast and comparison of why one is better than the other or isn't. Or just what's the difference between those two? Because to me, based on your explanation, I'm having a hard time seeing what the difference is.
So, Mr. Chairman.
Senator Kinski.
Okay, I was going to ask him to repeat his amendments, but we just got a handout that incorporates everything that he just said, so that helps.
So, Mr. Chairman, thank you. What I think our solution does is cites existing law on what we can do, not speculation on what we might be able to do. My worry is we're going to set up, in this statute, we may set up the belief by the public that we, the state of Wyoming, are going to enter every class action lawsuit or lawsuit taken up by any employer or employee. And so what this does is just it just repeats what the Attorney General can do in existing law. And is it a fine line? Yeah, it's a fine line. It's been my understanding, and I'm a cowboy, I am not an attorney, but it has been my understanding we've kind of tried to avoid that class action stuff in bills. So certainly willing to hear other amendments, but that's our concern.
So let me reiterate so I understand what your proposition is here. As I look at this one that's handed out, so you're saying we would include, or we would maintain the Romanet I under B, which is the Senate language, and the House would offer up Romanet 2 that modifies that to a certain degree because it is existing statutory language and then would conform with other areas within our laws. Is that correct?
That's correct.
All right, thank you. Committee, any discussion?
Mr. Chairman, my question is, in the original intent of this, and it sounds like the phrase class action is what really is driving a lot of this. And so that language is not necessarily necessary as long as the intent of the balance of it is at least what I intended originally. And I think the body intended is that there's a lot of people out there that are hit by this mandate, but they don't have the resources to take on the federal government. Anybody versus United States, you better have pretty deep pockets. And so our hope here was that the state could, in the course of prosecuting its own actions against the federal government, that these businesses or individuals could join in, or maybe there's a situation where the state doesn't have standing, or there's a question whether it has standing, that that by joining these people in, they would be able to acquire standing and help carry a lot of the load for it, because these small businesses are not going to be able to afford it, nor are individuals. So if that intent is preserved there, I mean, is that what are we still trying to do that? I'd like to be able to help out businesses and individuals with the state's resources. Can we still do that with this change?
Mr. Chairman? Yeah, Senator, I with the draft language that was handed to us, I would answer yes. And I think the concern regarding class action is just the burden around, defining a class, certifying a class. It is a very, it's, I don't want to use the term bifurcated, but it's a two-step process versus if the state is able to step in where there's an interest, file the suit. And this language here gives the state the authority to initiate a suit on behalf of the state of Wyoming as a lead or other plaintiff for joining a lawsuit. I think it gets to that point that you're trying to get to without imposing that additional burden, cost, and time delay associated with a true class action.
Mr. Chairman. I still am struggling with the language in Romanet 2 that was just circulated. In Romanet 1, we talk about initiating a lawsuit, and then 2, we say we're going to initiate or join it. So I just don't know why we need to clarify the AG's ability to initiate it twice. I think the intent is to say, and this is how I'm trying to think it through, if you have a class of private plaintiffs who say that these orders are affecting their livelihoods, we want to make it clear that the AG can and encourage her perhaps to support those plaintiffs in those suits by joining. So I think adding the words initiating confuses the purpose of 2. I'm not understanding.
Senator, where would you insert that?
So, Mr. Chairman, in Romanet 2, rather than having initiating a lawsuit on behalf of the state, I think we could just say joining, delete those first 2 lines more or less, but starting with the word joining a lawsuit initiated by Wyoming residents who are personally injured or whose livelihoods is negatively affected. If an individual brings that lawsuit, then the Wyoming Attorney General's office can support it, move to intervene, write briefs, write an amicus brief, and lend its support in that regard. I think is the most we could hope for when it comes to those private suits.
Representative Swanitzer.
I'll have a question on that. Now I'm a little confused when it can be multiple lawsuits. And so now our AG can decide when to support multiple. And so if she says yes to one, she's going to have, if there are, 20 out there, I mean, maybe she can carbon copy the same amicus brief, but it does seem like we're stretching the office thin, and that's not exactly what I was anticipating when I was, well, I don't like the language at all to begin with, but would that be correct that, I mean, the AG's office, then we're giving them the power to pick and choose which lawsuits they want to join based on her own kind of personal opinion?
Senator Ellis.
Thank you, Mr. Chairman. It just does, to me, it doesn't make sense that they would initiate and then later join. Like if you initiate it, you're in the case. And we already made clear in Romanet 1 that they initiated, so they're leading that case. So Romanet 2, I think what the intent we were trying to get after was finding a way to support private litigants who've been aggrieved by the federal action. And one way of doing that is to intervene or join those cases. And so it's not a perfect solution, but 2 still doesn't make sense to me by saying initiating a lawsuit on behalf of the state of Wyoming as the lead or other plaintiff or joining. I just don't know why we have that sentence repeated twice.
Mr. Chairman. Mr. Chairman, my suggestion, and we can continue to debate this for a while, but then my suggestion is we set this one aside. We make sure we get Senator Ellis's verbiage down. So Representative Chairman Greer, go ahead. But I think we'll have to set this one aside.
Can we get that? I'd like to get that language before we move on. I didn't catch
So,
it.
Mr. Chairman, I think looking at Romanet 2, there's, you're right. It's repeating, initiating, but up above it's talking about initiating the action name of the state of Wyoming. And down here, it's restating that. I agree, but it's on behalf of Wyoming as the lead or another plaintiff are joining a lawsuit initiated by Wyoming residents. What it's doing is expanding the AG past representing the state of Wyoming, but still retaining the autonomy of the AG representing the state of Wyoming, but in essence saying the state of Wyoming is going to be representing and taking in the lead on behalf of businesses or citizens. And I think that's a compromise versus saying that they're going to initiate or set up class action suits.
Chairman Hicks, my suggestion is I'd like Senator Ellis to repeat that language so we can all write it down.
Thank you, Mr. Chairman. I believe LSO handed out a draft piece of paper to you. And if you read Romanet 2, it says initiating a lawsuit on behalf of the state of Wyoming as the lead or other plaintiff, or joining a lawsuit initiated by Wyoming residents who are personally injured or whose livelihood is negatively affected by federal vaccine mandates pursuant to 91603A Romanet 4. It would look at deleting, just saying initiating the lawsuit on behalf of the state on line 1, deleting that whole line. On line 2, start deleting of Wyoming as the lead or other plaintiff or. So what would remain is joining a lawsuit initiated by Wyoming residents who were personally injured or whose livelihood is negatively affected by a federal vaccine mandate.
Okay. So, Mr. Chairman, what I would suggest is we set this aside. Probably the House will go out and caucus on that issue and come back, and depending on what the rest of the Senate wants to do as well. I mean, if that becomes a Senate position, then we'll probably go caucus on that. So would you like to move on to the other ones?
Yeah, let's do, Mr. Chair.
Let's go to the easy one, which might be section 4 with the appropriations. So where would you guys like to land maybe on that?
Mr. Chairman, I think we've already stated where we'd like to land, and that's $10 million for the very reason that we just discussed. And so if in fact we were so inclined, the AG on behalf of the state joining lawsuits, now we just want to make sure that there's adequate funding. It could require the contracting with outside counsel to do that. We certainly don't want to limit the ability for the state to join or initiate any lawsuits along these lines. And so it was our predisposition to make sure that they were adequately funded, and that was the $10 million.
So, Mr. Chairman, we want to stick with our original $1 million, and then it got reduced on the floor of the House. So we decided we'd go up from the 250 to $1 million. So what, $1.5 million? Where can we come to some agreement here?
Mr. Chairman,
Please, Senator Kinski.
in defense of the 10 million, there's businesses that are severely impacted by this mandate. There's a lot of individuals that are clearly upset over the mandate. They don't want to have to be forced to take a vaccine. It's really, and I think Chairman Hicks alluded to it. It's Representative Swanner was concerned about whether we'd overload the AGs. I think the intent is, as Senator Hicks said, is they go out and get the best legal guns they can and get something going if they're so inclined. So I hate to spare the horses, because I think the 10 million, well, it sounds like a big number compared to the impact on lives and businesses. It's dwarfed by that. So the intention was to give the AG the resources to get something ginned up and roaring right away.
So Senator Kinski, I guess I would offer that in a few short months, the AG will be in front of, the AG's office will be in front of the Joint Appropriation Committee to ask for appropriations. Obviously, if we are short, if we're light on, if we put in $1 million, let's say, $1.5 million, and we're light on that based upon the law we passed, certainly. And remember, this is over a 10-year period that we're parking this. So, we can't change that 10-year period, but certainly you all will have in the Appropriations Committee the ability to come in, get testimony from the AG on how much money will likely be needed in the next biennium to handle this, and then you'll be able to appropriate above what's in this bill. So I don't think we're comfortable with that figure at 10 million. especially in light of the fact that appropriations will be meeting soon.
Chairman Summers, I would just say, you do bring up a valid point that we'll be back down here. And we can look at this again, but that being said, there's additional reasons I think it's important that we include it. So I would offer up that we would consider $5 million, which is close to splitting the differential. But I also think there's utility to not only are we going to pass the law, but we're also going to say that we're pretty serious about this. The state of Wyoming is committed to making sure that we have adequate financial resources right now to instigate any of the actions that are unforeseen today that may present themselves tomorrow. So I would say we would be receptive to $5 million, given the explanation that we will be back down here. But I do think there's utility to, if you say you're going to do it, give us the tools to do it. So that, Mr. Chairman.
So how about we split that and do 2.5?
Mr. Chairman,
Go ahead.
Senator Kinski.
I guess I'd say this. My experience on the appropriations committee is it's generally pretty difficult to get some of the House folks to go along with what we see as a priority.
7.5.
Mr.
Keeps
Chairman,
coming.
I mean, I honestly don't care if it's 10 million. We just need to have it revert in 2024. We go back and we've got it, shall revert on 2030. Just needs to go back in front of appropriations and not have that money tied up. So, we did 5 million. I don't have a problem with the 5 million. If they need more, they'll have to come back for it. I'd be more concerned about changing the reversion date, which really isn't in our prerogative, in our purview right now,
Right.
unfortunately.
Yeah, and Representative Greer, that's why we can't change the reversion date. So that's why I would just suggest we go to 2.5 and then appropriate more money if it's needed.
Mr. Chairman,
Senator Ellis, please.
I think the reason that we set it a larger amount isn't just for the recognition that we'll be back in February. If we're trying to have a long-term litigation strategy, it would be helpful for the Attorney General's office to have some kind of budget, knowing that what they're going to work on with the next couple of years. And so I do think we set up a dangerous precedent by saying, well, they can come back and ask us next year for 100,000 more. They can come back and ask us, because there's no certainty in planning their litigation, a long-term litigation strategy, if and when these rules come out.
Representative Zwanitzer.
And to take the inverse of that view, we're saying we could represent anyone and the AG's office could jump on any number of lawsuits and there's $10 million. And so if I'm a member of the public and I feel aggrieved, why would I not go to the AG and say, hey, you have $10 million, represent me too. Every member of the public and every business in Wyoming is going to want the state of Wyoming to jump in on their lawsuit and help them out. And I think the barn door is open too wide by that language plus the 10 million. And that should probably be in the conversation of how expansive we're allowing the Attorney General to pick and choose which cases she's joining. And with $10 million, that's a lot of cases she could join, and a lot of people out there saying, you have the money, help me out too. I'm just thinking, as we're moving slow for the next 120 days, I think the 10 million is too high.
So,
No, Mr. Chairman, I think we've conceded that may be an appropriate number. So we're really discussing 5 million now. And back to that, it's permissive of the state or the Attorney General. So it's not like she has to, just because there's money there, join every lawsuit or allow somebody to join them. So, I think certainly 5 million is something that we consider. Let us discuss it. Maybe we can go back. I wish we could modify the effective date of that, but I would remind people that at any point in time, the Appropriations Committee can go back and grab that money any year when we're back in session, either through the supplemental or the regular budget. So that, while it's parked in that account, that it can be reappropriated by the Appropriations Committee for other purposes. Should it become at a point where this is struck down and it's no longer needed, we could recapture that money. But Mr. Chairman, I do think that there's room for compromise there, and that we should continue that discussion. But let's move on, and maybe we can find.
Let's haggle it. How about 4?
4? 2 for me and 2 for you?
No. Or for the Attorney
Oh,
General.
4 for the attorney. I just wanted to clarify what what you were offering up to
Yeah,
representative. And we do 4.
so move.
So move for 4 million.
Is there a second?
Let me check with my colleagues here. Colleagues, is 4 acceptable? Senator Kinski?
Sure.
Yeah, we would accept that as a friendly.
All those in favor?
Aye.
Opposed? Okay, 4 million. Okay, that was the easy one. Now let's go back. We said we were going to set the section 3 aside. So now let's go to section 2. And
I'm sorry, on section 3, Senator Ellis, I couldn't hear all of your comments. Do you have them written down so I can pencil them in? So I can look at that closer.
Thank you, Mr. Chairman. Romanet 2 says initiate a lawsuit on behalf of the state of Wyoming as the lead or other plaintiff. I'm just curious how we initiate a lawsuit with the or other plaintiff. To me, that language doesn't make sense. But I think the crux of what we're trying to get after is allowing and encouraging the Attorney General to consider joining a lawsuit initiated by Wyoming residents. I think what we'll see is individual citizens in Wyoming probably won't sue in a federal court. It's really expensive. What you might see are some trade associations and large corporations sue some of those federal mandates. And so I think by having Romanet 2 simply say joining a lawsuit initiated by Wyoming residents who were personally injured or whose livelihood is negatively affected would maybe be some compromise language to achieve what we're trying to get after. In those private lawsuits, when the state of Wyoming intervenes, it does lend weight, I believe, to the arguments that they present. They're able to present a different point of view than just the citizens. So that would be the language I suggest, but certainly open to other ideas.
So Mr.
Chairman Greer.
Chairman,
So I have a quick, I think we knocked this out.
Okay.
Because I'd say joining a lawsuit, all we have to do is incorporate that as a lead or other plaintiff to give the option. Is that,
So
then when we get the full
joining-
capture, would that alleviate your concern, Senator? And
Mr. Chairman, that's another way of doing it for sure. If you deleted, so we could put join in Romanet 1, say join or initiate an action. But I think what we're trying to say here is just make it clear that there might be lawsuits where individual Wyoming residents are harmed. If you read 1, it's pretty narrow what we recommend the AG take on as arguments. They're 10th Amendment arguments. So I just don't want to confuse the two. Our arguments will probably be different than a lawsuit initiated by a private plaintiff.
Representative Greer, so you had some language and I'd maybe go over that again.
So one, Mr. Chairman, I agree with Senator Ellis's number, Romanet 1's very narrowly defined. So now we're broadening this out. So if we strike the language that she said to strike, and then where we're at that joining, so join a lawsuit, and I'm just throwing this out so we can move on and get done, is join as a lead or other plaintiff or other plaintiff, a lawsuit initiated by a Wyoming resident, giving the state of Wyoming to be the lead if they felt the need to.
Mr.
Senator
Chairman.
Ellis?
Thank you, Mr. Chairman. I don't think it's how it works. Whoever initiates the lawsuit is the lead plaintiff. So if a private individual initiates the lawsuit, they're the lead plaintiff. And Wyoming does this all the time on federal natural resource cases. When we join to defend the BLM on a decision or fight with them, we file a motion to intervene. We're never the lead plaintiff or the lead defendant.
Okay, no, I'm fine. Just having a discussion. We can strike that clause. It just narrows us down to what the state can do for citizens. And if that's a sense position, I'm fine with that.
Representative Swanitzer.
I need to back up about 5 steps. So we had 2 bills originally in the House. One didn't make it to the Senate, 1001. And this bill, from my understanding in the House, was about public entities and what they were required to do. This section, I mean, this opens it up to any Wyoming resident who's aggrieved, private business, any entity. It no longer deals with those aggrieved by a public entity complying with a mandate. I just want to make sure that seems a little more expansive than the rest of the bill. And and I know we had two bills and the other one's gone, so maybe this is the catch-all. Does that present any concerns that this is much wider than, the legal changes we're making to build a statute?
So Representatives Wanitzer, I've been looking at this title for a couple of days now, and this title is huge, right? An act relating to the protection of individual rights, providing legislative findings, prohibiting the enforcement of federal COVID-19 vaccine mandates as specified, providing definitions, authorizing litigation to protect the rights of Wyoming and the state of Wyoming citizens and the state of Wyoming. So clearly it's in there. So I think it's perfectly a perfectly good debate. So I'm hearing some movement, I guess, on our side. I think the Senate needs to decide where they're at on Romanet 2.
Mr.
Okay.
Chairman,
I think we might go along if we just get rid of class action.
Mr. Chairman, I just want to verify, just clarify for everybody where we are. The proposal from Senator Ellis is that on Romanet 2, we strike the first line and we strike the second line clear down to or, then you just capitalize joining and carry everything else forward from there. Is that what it is, Senator Ellis?
That's correct,
Is
Mr.
that your
Chairman.
understanding as well, Representative Greer, what the proposal is?
Say that again, Senator. You're talking about
Go
striking,
ahead.
initiating a lawsuit on behalf of the state of Wyoming as the lead other plaintiff, or strike to there and then just go with joints. If you want to narrow it, that's fine. I would prefer it was narrowed, so.
So, Mr. Chairman, if the Senate wants to make that motion, that's up to you guys. If you like Chairman Greer's proposal, then we'll make that motion. But I'm curious where you guys like. We're fine with the Senate's. We're fine with Senator Ellis's, depending on what you all are good with.
So it's our motion. So, Mr. Chairman, what I would do would be to go in and on Romanet 2, strike all of line 1,
Okay,
all of line 2 through the second or,
gotcha.
and then starting with joining, capitalize that and put joins a lawsuit initiated. So that would be the motion, Mr. Chairman.
Is there a second? Moved and seconded. All those in favor of the motion, say aye. Aye. Opposed? Motion carries. Okay, we're 2 out of 3. So now we're back on page 7. And the House position is as it was before you all amended it. And basically, the long and the short of that is we want our state law, we want the state's position to stay in place during a stay. Your position is it goes away, the state's position goes away at the beginning of litigation. So we want to keep our sovereignty as long as we can. We believe it still protects all of the entities. And that's, and it is like a light switch. It could turn on and off.
Mr. Chairman,
Senator Kinski.
so just top line, if our language does not preserve the state's sovereignty, I certainly want to hear about that. So our amendment did a number of things, and if we could just start at the top of page 7. Yeah, I want to make sure what it is that the House did not agree to. At the top of page 7, from lines 3 to 6, the Senate struck language beginning after Romanet 8. That was the first part of that amendment. Next, on lines 14, the Senate struck the word to, and then struck all the balance of that language down to through line 20, and substituted language that is here in green. I won't read it. I just want to make sure that was the second part of the Senate second amendment. The third part of the Senate amendment was in subsection D, line 23, striking the last word during, continuing on to page 8, and the Senate struck lines 1, 2, and 3 down to the word otherwise and inserted some new language there and preserved the balance of that. So that was that was the second Senate change. Or is that the third Senate change? The fourth Senate change was on page 8, lines 7 to 11 was struck in its entirety and a new section E inserted. So there's 4 there. Which of those 4 are of concern, all or some? I just want to make sure what we're talking about.
You bet. Representative Greer.
Thank you, Mr. Chairman. So Senator Kinski, hours of debate over this issue on the House floor. And I understand the Senate's position on this, but here's where this comes down to, and I don't know if we would get this through. This will cause an issue with us. And so the language that we ended up with in the House was in and of itself a bit of a compromise. We have a very strong group of individuals, majority, who just flat want to just say no to the federal mandates, and consequences be damned.
Yeah.
Quite frankly.
Sounds familiar.
What this language does, though, is if a federal order or mandate comes down, it means that the state law is not going to be enforced clear until the end of all of the litigation or resolution of that particular mandate or order.
The Senate's version.
The Senate's version, correct. In the House, what we did was provide the opportunity, if an order comes down, that order goes to litigation and a stay issues, staying the enforceability of that federal order, then our state law would still be in effect. And that's all we were doing, was just finding that, which again was a compromise even in the House to get to that part. So just so you're aware of how we got there and why we had the language we had.
Mr. Chairman.
Senator Ellis, please.
Thank you. When you use the word stay, I just want to be clear, because there are terms of art. You know, you could have a plaintiff seeking preliminary injunction, restraining order, TRO, whatever. I just want to make sure I'm understanding. Are you intending the word stay to be interpreted broadly? Because we list out everything in prior pages about law, regulation, order, whatever. Here, I just want to make sure that I understand that it's not just limited to a stay, because you could have, you know, a temporary rule by a judge, which isn't fully a full-on stay, if you will.
Representative Greer.
I mean, if that helps us get home to add those other things in there, that's fine with me. I think if the order is stayed through whatever mechanism, what is brought it's stayed. But if you feel that it needs to be clear, it's fine with me.
Senator Ellis.
Mr. Chairman, I don't have a solution. I just want to make sure we're telling regulated entities and being clear with them so they understand. I don't know if they understand that or not.
So that's the House's position. I think the only other thing that I think we saw going through this was a minor cleanup on, and I'll go to that, Mr. Chairman, a minor cleanup on someplace, I believe, in the findings where we had, maybe it was in the resolution. I've got to look here for a minute. Yeah, there was an egregious. You got that? Page 8. Right, there it is. I got it. It's been moved and second that we strike egregious on page 8 in Romanet I, B Romanet I. All those in favor say aye.
Aye.
All those opposed? Motion carries.
Mr. Chairman.
Senator Kinski.
So I hear what Representative Greer is saying, and Representative Greer's attentions were directed to the Senate amendments in paragraphs C and D as being the objectionable ones in the House. So do I infer from that the House was okay with the first part of the Senate's amendment, which was lines 3 through 6, and the second part of the Senate's amendment, which was on page 8, lines 7 through 11, or did the House object to those amendments as well?
So Senator Kinski, there's going to be people in the House that object to any of this, right? I think what I'm suggesting is we would cede back to the original language in the bill, which was public entity under 166101A8, and we would go with the Senate striking the rest of that language. And then we would also concede to the removal of the House E and the addition of the Senate E. So basically, other than these three things, we're good with everything else you did.
Well, Mr.
I still, just 1 minute. Say that again, Representative Summers. I heard you say you're okay with E in the new language. What was the first part of it you said the House is okay with?
So other than the three sections we talked about that we're dealing with, we're good with all the Senate changes. So the Senate changed section, basically the definition of public entity. They struck out the language that was added in the House on an amendment. The Senate goes back to the original definition that was under 166101A8. I think this conference committee is good. There'll be people that won't agree with that in the House. But we're going to agree to that. But, I think that, and then on E, E was a completely different piece. And we realized that the Senate debated that in an entire bill and failed that bill. And obviously then you struck the language that would have brought that back in this bill. So why fight that, die on that hill? So we would agree to replacing our E with your E.
So then, Mr. Chairman, if I may. So
Please.
So then turning our attention then to C and D, which is where the rub is. At the outset, you said something, your language makes the law go away. And so I wonder if you could walk me through that. Do you remember that? That's what caught my ear. Representative Summers said that just at the beginning.
Unenforceable.
Unenforceable.
The law does not go.
No, the law stays there, but it's unenforceable through the entire litigation process, including in impendencies. And so it's basically set aside. The House position is if the judge makes a stay, then Wyoming's position stays in place through the stay.
So let me see if I can make a proposal here.
Very good.
So, and I'll have to confirm with my colleagues, but so I would say, so we go to page 7. The House has indicated that on lines 3 through 6 that you would recede to the Senate's position, and we would accept that. Then we get down to lines on subsection C, line 14 through 20. You've asked the Senate to recede from our position on that and adopt the House's position. Further on that, so we would then have to do that, then we would have to recede from our new language that we brought in under subsection C. That would be part of the motion if we were inclined to do so. And as we flip over the page, we would also recede on that language because that's part under D now, and we're on page 8. You're asking us to recede from that language, correct?
Correct.
And then you would recede, you would accept the Senate position on deleting subsection E, correct?
Correct.
Okay, the only thing I have left to clarify is what do we do with subsection E that the Senate had? Does that,
They accept.
well, it doesn't work though. Because it also goes back and says, this references until subsection B of this section becomes enforceable under subsection C and D. That was C and D of our amendment, not the House's amendment.
But Representative Crago and I were looking at that. I'm sorry, Mr. Chairman. But it actually coincidentally does work.
It does work.
Yeah. I was concerned it didn't, but we're talking about B, which is the no public entity shall enforce, becomes and then the term enforceable. becomes enforceable under subsection C.
All right, so you
Yeah.
would accept the Senate's position on that?
Yeah, I think we should ask LSO to just
Right.
make
Yeah,
sure,
well, before we
make
take
sure I'm
anything
right.
out to
Yeah.
the floor, we would ask.
Right.
for
So Heather, if, you know, you guys in LSO, check it out. Do you think it works? And then check it out with the crew.
I'm going to consult with council.
So,
So before you leave, Representative Greer, I just want to make sure that you and I are both reading. it.
Well, he's
Oh,
keep
okay.
dragging another lawyer into it, so
Yeah.
we'll
There'll
just,
be an argument.
we'll wait a minute.
Any town that can't support one lawyer can always support two.
Mr. Chairman, so I want to run back through this and then.
No,
I'd
let me
like-
let Chairman Greer
Okay.
finish his thoughts, maybe he learned something.
Okay. And Representative Drago made this point. So going back to E, Mr. Chairman,
Senate E.
Senate E, correct. Okay. Until subsection B of this section becomes enforceable. In what we're becomes enforceable under B, we're saying what I think we should do is just reserve that we've got that flows correctly. There's just that clause in there.
That's my concern.
Yeah, we need to double check that, make sure we're correct on
So
that.
here's
Yeah.
what I would recommend. So
So
I
you make a
want to,
motion.
I want to run back through, well, I don't want to make a motion, but I want to understand that this would be under consideration. And what I'd like to do, Mr. Chairman, is visit with my colleagues. So
Okay.
on page 7, line 3 through 6, the House would recede to the Senate's position. On page 7, line 14 through 20, the Senate would recede to the House's position.
Right.
The Senate would then agree to eliminate or recede from our position on the new subsection B. So we would basically give that up. So we would also recede to that. And then as we turn over, beginning on page 7, that's a continuation. We would recede for that. And then when we get on page 8, line 8, the House would recede to the Senate position, and we're waiting for some clarification on Senate E.
Correct.
Okay, if we could do a caucus, I want to run that past my,
Okay.
so that we're completely clear on what the proposition
So,
is.
Mr. Chairman, if I may, just for your consideration while you go into that, on the Senate subsection E is, so we'd go, nothing in this section should prohibit a public entity from applying for a federal grant or federal reimbursement and verifying compliance with a federal COVID vaccine mandate. And this is just for discussion. While, until that we strike until, while subsection B is enforceable, period. And just look that over.
While subsection B is enforceable. Okay. All right, we need to go visit, and you want to set a time to try to be back?
Sure. Mr. Chairman, you got any sugar beets? It's 4:37. How long does the Senate want?
Give us 10 minutes.
Okay, at, so at
4:50?
4:50.
All right.
4:50 will return.
See you gentlemen at 4:50. All right.